We'd like to call the event to order and welcome everybody. I'm Marty Guggenheim. I co-direct the Family Defense Clinic and am thrilled to invite you here, to see you here to the first ever in what we hope will be a long line of formal Ellie Hirschfeld Child Welfare Panel Symposia that we hope to hold annually. About a year ago, I met Ellie Hirschfeld, who is seated here, and we started talking, and he finally remembered his wonderful experience as a third-year law student at this law school when he took the criminal defense clinic. And it happened to be that the year in which he took that clinic was the first year that I was teaching in the clinical program here as well. And his favorite teacher was my closest colleague at the time, Chet Mirsky. And we talked about those good old days. And then I told him, well, for me, those good old days have continued, but I shifted my work from criminal and juvenile defense to family defense, and that led to, well, what exactly is family defense and what did you do? What do you do in the clinic? And after explaining that, he said, that's awesome. How can I help? And the answer was, well, we could use some financial support, and we worked out an arrangement. We have, for years, wanted to expand our capacity to do appellate work because everybody who does this work realizes that the best way to get a judge to obey the law is to appeal an illegal ruling. And we were, as a consequence of this support from Mr. Hirschfeld, able to create the first Ellie Hirschfeld Fellow. The magnificent Amy Mulzer is our fellow. And we have been working together since August. And then the last part of the gift was the idea that we should convene on an annual basis to bring together people to talk about important issues in child welfare. And if I know anything about creating something that's useful, it is you start with the very best in the world. So the goal was to create today the rock star panel that we have. And I'm now more than thrilled to turn over the proceedings to my close colleague, Chris Gottlieb, who will take over from here. Thank you.
Thank you, Marty. Thank you, Ellie, for bringing us together. I also want to welcome everyone. Having started in family court 20 years ago when this kind of gathering was really unimaginable, it's still just really heartwarming to me to see a room, and a little bit surreal, honestly, still, to see a room of top-notch lawyers, social workers, parent advocates, parent activists who really care about family defense and really care about making the child welfare system better. That's not the kind of room that was around 20 years ago, and it's very special to me to have you all here. Let me first just tell you the plan for the evening. We have asked each of our panelists to talk with you about the issues and ideas that they've been working on recently. We'll ask each of them to take a turn doing that. And then in the second hour, we're going to open it up for discussion. We'd really like to have a robust conversation about what the panelists have been thinking about, what you've been thinking about, and maybe what kind of next steps we can think about taking together. And then at 7, we'll break into a less formal kind of conversation where we hope you'll stay for the reception. It'll be in this room, and continue to talk over wine and snacks. But my privilege for the evening is to get to introduce our panelists, and I really do feel privileged to do that. We have Kiara Bridges here from Boston University, Dorothy Roberts here from the University of Pennsylvania, and our own Peggy Cooper Davis. I decided that for the introduction, I'm not going to go through the list of their accomplishments because I don't want to take that much time as it would to do that, even just to list the writings of the three people that we have here that have profoundly affected our field. Just listing those would take too long, so I'm not going to do that. I just wanted to take a minute to say why I think it's particularly meaningful to have these three particular individuals here. And in the last few weeks, as this event has been approaching, people have been coming up to me. I mean, students, my professional colleagues, parent activists I work with. I mean, there just has been a buzz about this event that I think it's fair to say isn't normally associated with a law school panel, with law school faculty on it. I mean, I have felt an energy that I think is meaningful. And when I thought about why that is, it occurred to me that I think that the three of you who are here have played, for those of us in this room, a role that, a really important role that in some ways is analogous to the role that those of you who work in this field play for your clients. And what I mean by that is that one of the things that lawyers and social workers, parent advocates, and parent activists do for people who are dealing with children's services is, in addition to fighting for them in the courtroom and the agencies, and those are super important fights, of course, but I think separate from the fights that you're fighting, you provide something really valuable to people who are dealing with children's services simply by really seeing some of what is happening to them. And letting them know that they're not crazy to think that what is happening to them is not okay. And they're not crazy to think that what's happening to them has to do with race. I know that the people in this room are sending that message implicitly and explicitly to the people you work with on a daily basis. What I realized is that Kiara and Dorothy and Peggy have, in a sense, played that role for us. That is, in their writing and their speaking, they have acknowledged what we see every day, and they have told us with the authority that their academic prowess gives them that we're not crazy to think that what we see is not okay. And we're not crazy to think that it has to do with race. And to give us a language to speak about that and to think about it and to figure it out and not just feel it and be hurt by it, but to start to grapple with it. I mean, that has really been a gift that I think these three individuals have given to all of us. And I think that accounts for the energy, and we're thrilled to have you here to take that conversation the next step forward. And I just would ask you all to join me in welcoming them, and then I'll turn it over to Kiara.
So thank you all for being here tonight. I am utterly humbled to be asked to speak to you because I feel like you all know a lot about this subject, and I feel like all of you could be panelists on this panel. And I'm also humbled to just be on the same stage as Dorothy Roberts and Peggy Cooper Davis. So I'm also not used to speaking in a handheld, and so I feel like Beyonce, so I might, I like it. I'll just say I like it. From now on. I will insist from now on. So like everyone here, I've spent a lot of time thinking about the child welfare system and why it looks the way that it looks and why it operates in the way that it does. And specifically, I've been thinking about why it is that the families subjected to interventions by child welfare authorities are overwhelmingly poor and disproportionately non-white. And I've been thinking about why it is that child welfare services operate so brutally vis-a-vis the poor families of color that are under its jurisdiction. Why does it seemingly remove children from their parents so gratuitously? And once children are removed from their families, why do family reunification plans require parents to do things that have nothing to do with the reason for their children being removed in the first instance, right? Why do these plans require parents to undergo things like anger management classes and vocational training and parenting classes and substance testing in order to be reunited with a child that may have been removed for reasons that have nothing to do with a parent's anger or lack of vocational skills or approach to parenting or substance use? So in my scholarship, I've argued that the reason the child welfare system looks the way that it does and the reason why it operates the way that it does is due to the moral construction of poverty. The moral construction of poverty is the simple idea that poverty, that people are poor because there is something wrong with them, right? It is a profoundly individualist explanation of poverty, meaning that it explains poverty in terms of the individual's failures, right? It does not look to structural causes of poverty. It ignores things like a labor market that contains fewer middle-skill, middle-wage jobs than it did in decades past. It ignores things like the fact that women are paid less than men for the same work. It ignores things like the nation's choice to pursue mass incarceration as its means for addressing its social problems, which is a policy choice that does a wonderful job of impoverishing already impoverished people, families, and communities. And so the moral construction of poverty ignores all of these structural causes of poverty and simply concludes that people are poor because they're lazy, or they're irresponsible, or they're promiscuous and they like to have a lot of kids, or they just don't have a good work ethic, or don't like to work, or just feel entitled to government handouts. Now, note that if people are poor because there is something wrong with them, then there is nothing wrong with the demographics of the child welfare system, and there is nothing wrong with the way that it operates. If people are poor because there is something wrong with them, then the child welfare system ought to be focused on poor families to the exclusion of wealthier families. The child welfare system ought to be comfortable removing children from their parents' homes, and the child welfare system ought to make parents jump through hoops before reuniting with their kids. This is because if people are poor because there is something wrong with them, then when you're confronted with a poor parent, then by definition, you are confronting a person who has something wrong with them, but who is nevertheless raising a child. The fact of a poor parent means, by definition, that a child is dependent on a person who has something wrong with her. And so this is perfectly illustrated by the case of In re M.W. And I came upon this case because I read this book, I don't know if you guys heard of it, called Shattered Bonds. So the case involved the removal of a 6-year-old girl from her mother's home because the home essentially was dirty. And admittedly, it was dirty. The court described the home as follows. Inside the apartment, the worker discovered the entire front room to be strewn with a collection of garbage, clothing, and other general clutter. Ashtrays were filled to overflowing with some knocked over. Windows and screens were missing. Garbage materials were embedded in the carpet. They had about 12 kittens or cats living in the house. Squalid conditions in the kitchen, dishes stacked in the sink on the counter on the table, cat box filled with excrement found in the kitchen. Some of the cat's excrement was stuck to NMW, the child's clothing. So the majority upheld the removal of the child from the home. However, there was a dissent, and this dissent rightly observed that the state would spend more time removing the child from the home than simply hiring somebody to clean the house. Now, so the question is like, how does this make sense at all, right? So if we view the case, and if we view NMW's mother's home through the lens of the moral construction of poverty, the case makes all the sense in the world, right? We can see how providing a cleaning service to this woman would not have really solved the problem. Essentially, the dirtiness of the home is not the problem. The moral construction of poverty tells us that the dirtiness of the home is simply a symptom of a larger pathology. A pathology that touches on the moral character of a woman who would allow her home to arrive in such a state. See, so one can see an argument that there has to be something wrong with a person, morally and perhaps psychologically, for her to be willing to live in such conditions, right? If this is the case, then hiring a cleaning service for NMW's mother and returning the child to the home is simply insufficient. Sure, the child would have been living in a clean home, but she would still be at the mercy of a woman whose character is so compromised that she would be willing to live in such conditions. So that explains why the court felt comfortable removing this child from the home. The state just can't fix the discrete problem of the dirty house. It just can't hire a cleaning service. Instead, it has to fix the parent through anger management classes, through vocational training, through parenting classes, through drug testing, and so on and so forth. And I think that the moral construction of poverty explains why the child welfare system tends not to try to fix isolated problems. Instead, it attempts to fix problematic people, that is, poor people of color. However, recent events have caused me to question the universality of the moral construction of poverty. In other words, I've had to reconsider whether the moral construction of poverty applies to everyone. Until recently, I felt pretty confident as a general matter that people have assumed that people are poor because there is something wrong with them. Now, I've always recognized that structural explanations of poverty, which again insists that macro, large-scale forces sort of work to impoverish people, I've always recognized that those sorts of explanations of poverty have some degree of salience in the U.S. For example, in the early days of the 2016 presidential election, Jeb Bush, back when he was trying to secure the Republican nomination, he had this quote that circulated in all the major media outlets in which he said that Americans needed to, quote, work longer hours and through their productivity gain more income for their families. And then he got pilloried for making that comment. People said that Bush was arguing that workers were not working hard enough if they were not earning enough money to support themselves and their families. Essentially, people said that Bush was saying that if people couldn't make ends meet, it was their own fault. And note that people were accusing Bush of embracing an individualist explanation of economic successes and failures. The kicker is that Bush eventually disputed this explanation of his work longer hours remark. He stated that the remark was not an argument that workers who were having trouble supporting their families are lazy. Instead, he said it was an indictment of the lack of full-time jobs available in the labor market. He said that his comment was a measure of his concern for the 6.5 million part-time workers who wanted to work full-time. So note that Bush recognized the political inadvisability of blatantly individualist explanations of poverty and low income. And in light of that political inadvisability, he instead embraced structural explanations of the phenomena, arguing that the country needed, quote, high sustained economic growth in order to solve the problem of the evaporation of the livable wage. So, but the Bush incident suggests that structural explanations of poverty and low income have had some degree of traction. That said, although these explanations pop up every now and again, I have always felt confident in concluding that they have not deeply saturated the culture, at least not to the extent that individualist explanations of poverty have. For example, there's a substantial literature documenting that the most favored explanation of poverty in the U.S. is one that identifies individual behaviors as the root of indigence. There's a social psychologist who has done a poll of the polls, essentially. She summarized all of the literature on this question. And she says, most of these studies find that Americans believe that there are multiple determinants of poverty, but that individualistic or internal causes, examples being lack of effort, being lazy, being low in intelligence, being on drugs, those individualistic causes tend to be more important than societal or external ones, like low wages, like being forced to attend bad schools, right? So she summarized the literature and found that for the most part, people embrace individualistic explanations of poverty. People embrace the moral construction of poverty. And then there was a poll that was recently conducted by the Pew Research Center. And the poll confirmed that a majority of Americans believe that the poor are responsible for their poverty. 60% of the respondents agreed with the proposition that, quote, most people who want to get ahead can make it if they are willing to work hard. And that same poll showed that 76% of Republicans versus 49% of Democrats reported holding the belief that most can get ahead through hard work. Now, those figures are interesting, right? And one might cite them just to show that conservative folks with conservative politics are more likely than those with liberal politics to believe that individual effort and the lack thereof produces economic successes and failures. But that same poll can be shown to cite, or can be cited to show, that close to half of those folks with liberal, quote unquote, liberal politics believe that individual effort produces economic successes and failures, right? So yeah, I've been pretty confident that most people will believe that people are poor because there's something wrong with them. Most people believe that the moral construction of poverty explains poverty. However, I had a come to God moment, if you will. It was November 8, 2016, and Trump was elected to the presidency. And it was only then that I realized that individualist explanations of poverty and the moral construction of poverty have a great deal of traction when they are offered to explain the poverty of those without race privilege. It was only on November 9, after I woke up with this migraine, that I realized that structural explanations of poverty have a great deal of traction when they are offered to explain the poverty of those with race privilege. Very few people believe that individualist explanations of poverty can explain the white poverty of the Rust Belt. Very few people believe that individualist explanations of poverty can explain the white poverty of the people who live in coal country. The country has, for the most part, both sides, right, Republican and Democrat, conservative and liberal politics, both sides have rejected the idea that white folks living in that part of the country are poor because they're lazy or irresponsible or have a bad work ethic or are promiscuous or feel entitled to government handouts, right? People on all sides of the political spectrum are convinced that white folks in the Rust Belt and coal country are poor because of structural forces. The industries that once supported these families have been moved overseas, or environmental regulations have limited the profitability of certain industries and they've gone elsewhere. These are decidedly structural explanations of poverty. They are not individualist explanations of poverty. So recent events have caused me to take even more seriously the way that race impacts the explanations that we offer for poverty. Structural explanations are the domain of the race privileged, and individualist explanations of poverty are the domain of those who lack race privilege. And so it leaves us to wonder and to think through how we might leverage this embrace of structural explanations of poverty of those with race privilege. How might we get folks to embrace structural explanations of the poverty of the people of color who are under the jurisdiction of the child welfare system? I firmly believe that if we as a society thought that these poor parents were fundamentally good, then our child welfare system would look a whole lot different than the way it currently looks, and it would operate completely differently from the way that it currently operates. Thanks.
Yes. Good point. There are seats open here in the front. I know they say reserved, but you all should come up and use them if you don't have a seat. Absolutely. And now we're going to turn it over to Dorothy.
Okay. I too am very grateful and honored and humbled to be here. It's a much bigger audience than I expected. And like here, I feel as if I'm among people who are experts in this field, advocates and very knowledgeable and very committed. And so I'm just grateful to be with you and share some of my current thoughts on this topic of the punitive child welfare system. I guess I'd like to just add to the example that Kara gave. I think it's absolutely true that structural explanations for inequality apply to white people in America, and not only behavioral, but even biological explanations have been applied to Black people and other people of color. Another area where we can see this is the rising death rate among whites in the United States, largely from drug overdose and suicide by guns. And the explanations for those have not been at all that these people are biologically predisposed to drug addiction and violence. Those are explanations that continue to explain in the media and even in scientific literature drug use by Black people, and in particular, biological explanations about Black mothers who supposedly reproduce children who are destined to be social deviants and criminals and welfare cheats and that sort of thing. So there is this very stark difference, and I agree, across the political spectrum, because we hear very conservative politicians pointing out relatives that they have who have drug problems and explaining it as social conditions that are creating it, at the same time that the idea that Black people are predisposed to violence, criminality, and drug abuse continues to circulate. And in fact, not to plug another book of mine, thank you, Dick.
I can do that as
My latest book, Fatal Invention, is about the biological concept of race. And some people say, well, how is that connected to your work on the child welfare system and reproductive justice? Because these underlying ideas of biological predisposition of especially Black people to take poor care of their children and to rely on welfare and to become criminals underlie everything we're talking about now, and support a view that a punitive system of child welfare is good. It's good for Black children because they are being raised by people who are innately incapable of taking care of them. So when I began to work on this issue, I immediately noticed that most of the children, in New York City in foster care were Black. Most of the children in Chicago in foster care were Black. And I was shocked that that wasn't a huge racial justice issue. Like I didn't, you have to know, you couldn't possibly work in this field without seeing it. And yet it was just taken for granted that that was how the system was supposed to work. And if anything, even after all these years of many of us advocating against racial injustice in the child welfare system, the term that's used is racial disproportionality, which suggests that it's just the disparate impact of child welfare on Black children because Black children need the services more, and therefore there's no need to change it. If anything, maybe we have to expand the services. But why is it that the service is a punitive, violent service of coercively taking children away from their families, of policing families, of policing entire neighborhoods? If you look at where child welfare agency involvement is concentrated in big cities, it's concentrated primarily in Black impoverished neighborhoods, segregated neighborhoods, and everybody in the community is affected by it. Everybody, whether they're foster parents, whether they're family members taking care of children, whether they've been removed from their homes and put in foster care, whether their kids have been taken from them. Someone in their family, someone on the block, someone in their school, little kids know what the van looks like that comes to take you away. Everybody knows. So we're talking about not an individual responsibility issue. What Chiara was talking about is the ideology, but it's a false ideology that's clearly false when you look at how the system operates. It is a system of state control of entire communities that operates in an extremely violent way that contradicts every principle supposedly that we have in America of family freedoms and constitutional rights, in ways that people are shocked when they find out that someone could come in your home and take your kids away without a warrant, without a court order. It's not even reviewed immediately. And once your child is in foster care, as you all know, it's very unlikely they're going to come out anytime soon. And so this, when you think about it politically, it switches from this question of individual parental responsibility to a question, a political question of power and of massive state control of entire groups of people. Why? In order to disrupt their families, in order to keep them occupied with, instead of organizing for change, even though it has not stopped many, many, many parents from organizing for change, but it's difficult. And in order to promote the idea that these communities are disadvantaged, not because of structural forces, but because of the bad behavior of parents in the communities. And so what I've been thinking more and more about, and I'm sure many of you have as well, is when you start thinking about the foster care system that way, it sounds a lot like prison, right? Yes, it sounds a lot like the prison system. It operates like the prison. You start to see this is not a service. This is not a helping organization, set of agencies. This is a punitive policing agency that functions to police, control, and punish communities much like the prison system. Then you start to notice, well, goodness, that's how the public assistance system works as well. We all saw that in the case, the young woman who was waiting to find out why her daycare, right here in New York, why her daycare benefits had been stopped. There's no place to sit. She's sitting on the floor. They come over, tell her she has to move, and we see the video of them yanking her child away as she's screaming and told, we're going to take your kids away from you if you don't comply. And we see, they ended up, she spent some time in Rikers. We see how in public benefits offices, there's a similar type of violent punitive approach. And in fact, public assistance is basically a behavior modification system. Now, there's no right to it. The whole point, which Congress said when it passed the Welfare Restructuring Law, a year before it passed the Adoption and Safe Families Act, there's a connection there, that it's designed to try to push mothers who rely on it, especially Black mothers who rely on it, into certain behaviors, marriage, not having any more kids, deter them from having children, and low-wage work, again, with the philosophy that the reason why they are in their disadvantaged position and come to rely on welfare is because they are not complying with family norms of marriage and not having kids if you can't afford to have them. We see the connection to the deportation system, which now all of America has seen, and some for the first time realize that the state takes children away from their parents. That got all this attention, and many of us had to say, guess what? That goes on every day in communities of color in the United States, and in poor white communities as well. We see the connection to the education system, the school-to-prison pipeline. We see the connection in the healthcare system, the way in which people have been brutalized when they seek healthcare, and that prisons are one of the main providers of mental health care in the country. We see it in evictions. We see, I could go on and on. My point is that we can see this punitive approach to inequality and family need in every single institution in the United States. And borrowing from prison and the carceral, the nature of prison, many of us are seeing that there is a carceral approach to people's needs that helps to explain inequality as a form of defectiveness of the people who are surviving the inequality, and instead of providing the public provision for people who have been harmed by structural inequality, the state has an extremely punitive and violent approach to these groups. So it's one way of looking at it is the way in which neoliberalism, the shrinking of the welfare state in the United States with the abolition of entitlement to welfare being one example of it, but we can see it in lots and lots of programs that have been slashed in the support for capital accumulation, that it's like really exaggerated under Trump, where every single policy is about making rich people richer and punishing people who are trying to struggle in this era of shrinking public support. And the flip side of privatization is increased punishment, policing, surveillance, and punishment. And now we can see how the foster care system is part of this expanding carceral approach to families' needs. And when we see that, we could see why the idea that the only solution is abolition for prisons, that is the approach we should take to foster care as well. There's no reforming a system that was designed to punish people and that has expanded, like the prison system and like the welfare system, expanded in its punitive approach as more and more Black people became involved in it. It's absolutely connected to racism. You can't explain mass incarceration, the explosion of foster care, and the abolition of welfare without seeing how racism fueled all of these, and how they have led to these disproportionate numbers of Black people in the system. It's not, it didn't just happen that way. It was designed that way. Now, I just want to close with a topic that I've been paying greater and greater attention to that is related to this expanding carceral regime, which includes the child welfare system, and that is predictive analytics. Big data, automated decision-making, and predictive analytics. Again, it's not just a coincidence that, just a result of advances in science that state agencies are using these tools to help them police and punish people. It's because these tools are useful to punish people. And I'll just point out 3 features. It's big data, so that the way in which government agencies are making decisions are based on huge data sets and algorithms, mathematical algorithms that interpret the data to make, number 2, predictions about people's risk of committing crimes or maltreating their children, or cheating welfare, or whatever, not doing well in school, whatever institution we want to pick that's part of this carceral net. Predictive analytics helps, and again, related to what you were saying, Carrie, it's not about individual responsibility anymore. It's about a prediction that you may do something in the future. And that prediction is based on an automated decision or I should say the automated decision is, the prediction leads to an automated decision. Now, this is supposed to be more efficient, fairer. It's supposed to now take away all the bias that we've seen in the foster care system, in judges, it's sentencing by judges, in parole officers' decisions. And it logically seems to make sense. Well, if you've got a computer doing it, it's better than a human being who's biased doing it. But the problem is that all the bias of human beings in the past is put into the data and the algorithms. And then the algorithms are learned. They continue to change based on the algorithm itself and the data that it's interpreting. And so you end up with structural inequalities and human biases built into these predictions. I'll just give a quick example. There's a great recent book by Virginia Eubanks, Automating Inequality, where she looks at this in public assistance programs. And one of the programs she looks at, the only people included in the system were people who relied on government public assistance benefits. So it excluded all the elite people in the community to begin with and just included people already. So that's one form of bias. But the factors that determine whether someone is going to commit a crime in the future, or is going to do poorly in school, or is going to maltreat their children, are factors that are biased in the first place. So, for example, that you've got a relative who was incarcerated. Well, we know that incarceration is biased by racial profiling and sentencing decisions and concentrating in particular communities to even detect crime. And so all of that bias is built into the data and the algorithms in the first place. And the idea that people are risky, and those are the people who need to be monitored and punished and their kids taken from them or they're incarcerated, deprives a decision maker from actually assessing the individual culpability. So now, these systems, it's not about individual culpability, it's about the risk that's created by your social status. So they're just reinforcing the inequality. And the prediction then, that this is, I'll end with why I think what is at the heart of why these are so valuable to a carceral state and why we should be very concerned about it, is that what the automated decision is a prediction of the future that is based on past inequality. So there's no opportunity in it for human beings to imagine a more equal future. It's a way of saying, we have a new system here that is going to perpetuate past inequality, and it will automatically do that. Yes, human beings are biased, but they can also organize for social change. They can also have their minds changed. That's why that's why we do what we do. We believe, right? that human beings can change. They can change social structures. They can change what they believe about the innate defects of other people. But an automated decision based on past inequality can't do that. And so we should be about figuring out abolitionist tools that allow for us to envision a better world that is not based on punishing people who are struggling because of structural inequality, but is based on a vision of a world that is not structured by these unjust hierarchies. And what are those tools? What even is the very way we can think about other human beings that don't rely on the kind of assumptions Chiara talked about, or the biological concepts that we're divided naturally by race? I think that's the chore that we have, or the beautiful task that we have in front of us, that we can see when we start to understand the child welfare system in political terms, as opposed to a system that deals with individual parents' irresponsible behaviors. Thank you.
Is this working? Oh, it is. How nice. So I echo the thanks to our conveners and to the supporters of our conveners. But I'm going to rush because we want to save lots of time to talk with you folks. And I have several things I want to say. I have to ask you to apply here the principle of charity that linguists sometimes talk about. And that's the principle that if someone says something that doesn't seem to make sense, instead of saying, oh, that doesn't make sense, you think about how it might make sense, and then you might understand the person, right? Because I'm going to make some leaps here, and I ask you to follow along with me. So the first thing I'm going to do is say that in 1980, I'm showing my age, shortly after I was sworn in as a family court judge, a more senior judge of that court looked me in the eye. She was a wonderful woman, and said, you know, we do things to families that we would not do to our own. She was a white judge speaking to a new black colleague, and so I understood that the kinship she was suggesting was a kinship of class. But she was a politically sophisticated woman, and so I understood also that the we was often white, and our own were white, and that the others to whom we did things that we didn't do to our own were people of color. The subject of this symposium, racism in child protective systems, seems a little bit remote from the subject of my talk. The subject of my talk is post-colonial constitutionalism. I hope that I can quickly show you how and why those things are related. People who are familiar with the child welfare system, and I think almost everyone in this room is, or with child welfare systems in other communities, will probably agree quickly that the comparison to colonization is apt. You have an entity, a child welfare system, that assumes authority over and supervises and alters the terms of life in a community and in families that had thought of themselves as autonomous. And it does so, most importantly, as my good friends with whom I have the honor of sharing this panel have pointed out, with a presumption of cultural or informational, if not biological, supremacy. And supremacy is the word to keep your eye on. It professes to act in the long-term interest of communities and families as it undertakes a kind of cultural or educational conversion. Kidnapping of Native children to boarding schools for socialization comes to mind, as do the orphan trains of immigrant children being shipped to more American homes farther west in the past. I want, though, to emphasize that the colonial metaphor is somewhat harsh, for child welfare agencies earnestly and sometimes honorably aim to protect children against the vices, failures, or incapacities of their parents, rather than the structural forces that make it difficult for their parents to care for them. So we can't fault the agencies for expressing this communitarian sense of responsibility for children with whom they have no kinship, no friendship ties, and very often no ties of affinity. That sense is appropriate and commendable, but I will suggest to you that good governments, good child welfare agencies, like good parents, must appreciate and respect the tension between liberty and loving care. And I'll suggest that governments that are self-consciously post-colonial have things to teach us about managing those tensions. When I speak of post-colonial constitutionalism, I refer to constitutional principles adopted in reaction to supremacist arrogance and atrocity. The South African post-apartheid constitution is the most prominent example, but it's joined by post-World War II constitutions of many other nations following independence from imperial powers. The German post-Holocaust constitution, while not post-colonial in the sense that it followed independence from an imperial power, is analogous in that it is reactive to supremacist exterminations and other policies. Analysts who are more knowledgeable than I in the field of comparative law have pointed out that post-colonial constitutional policies and practices vary widely in their embrace of human rights principles, and I know that's true. Nevertheless, there is a burgeoning jurisprudential and political set of philosophies that are self-consciously reactive to supremacist and imperial assumptions. I want to argue that we in the United States would be a better people and would have, among other things, a much better child welfare system were we to adopt a similarly reactive stance. Now, the United States is post-colonial, technically, of course, in the sense that our country was formed in rebellion against British imperial rule. We seem, however, to be in denial about our post-colonial status, and the United States is not usually thought of as a post-colonial nation. This has to do, I suppose, with the fact that the United States Revolution was more a rebellion of colonizers than of indigenous people, more like a Boer War than like an indigenous or enslaved people's independence struggle. I suppose it also has to do with the fact that many in the United States have thought of themselves as members of a white community, alas. Many still do. And colonization is typically thought of in terms of a white other binary. So, that said, I want to try to address 3 questions. How is it that we are, after all, post-colonial? Why is our post-colonial posture an especially important thing to give attention to right now? And what has all this to do with black families in the child welfare system? Okay, how are we post-colonial? I appreciate that we're post-colonial in an unusual way. The revolution of the 1770s was a war against distant monarchical rule, and clearly a role against governance without representation. But British rule over the 13 colonies was not as overtly supremacist as was British rule and the rule of other countries over lands that were populated by people of color. Disregard of native sovereignty in the United States and compromise with the institution of slavery factored heavily in the United States revolutionary calculus. The declaration that we are all created equal and endowed with inalienable rights was not explicitly given the force of law. And the Constitution that followed did not disavow, but only papered over the new nation's caste structure. it contained no equal protection clause. The Bill of Rights was an afterthought that protected only against abuse from the national government. States remained free to enslave and free to disenfranchise. Citizenship was undefined, and the Supreme Court was therefore able to announce in Dred Scott that African Americans could not qualify. So I invite you to think differently. I invite you to move from the 1700s and think of the United States Civil War as a war of liberation from colonial-style oppression. And to think of the post-colonial, the post-Civil War Reconstruction as the formation of a new nation that would stand, well, at least half-heartedly stand, against supremacist oppression. To think of enslaved people deserting plantations and joining Union armies. To think of abolitionists also joining those armies. In other words, to think of the United States as people engaged, at least since the beginning of the Civil War, in a struggle against supremacy and hierarchy, a post-colonial people. What are the 21st century implications of that? The idea of post-colonial constitutionalism is perhaps most easily described in reference to South Africa and South Africa's Supreme Judicial Court. Lawrence Ackerman, who once sat as a justice of that court, has explained that respect for human dignity, I want to repeat that, respect for human dignity, informs and enriches the proper interpretation of South Africa's constitution. And he made clear that dignity is intrinsic and inalienable to every human being. Remembering and responding to the indignities that apartheid imposed on Black and brown South Africans, South Africa's constitution explicitly establishes, and its Supreme Judicial Court consciously attempts to enforce, principles of equality and human entitlement to concern and respect. In the South African case, challenging laws that criminalize same-sex lovemaking, the Supreme Judicial Court noted that the experience of subordination, of personal subordination above all, lies behind the vision of equality. The court was required by precedent to examine the impact of discrimination on members of the affected group. And the court went on to examine in detail the indignities that were imposed upon sexual minorities as a result of the laws that were being challenged. And then to interpret South Africa's constitutional guarantees of equality, respect, and non-discrimination to require invalidation of those laws. I've written in the past about the difference between the South African court's treatment of that issue and the treatment it received at the hands of the United States Supreme Court in Bowers against Hardwick, and even in Lawrence against Texas. I argued that when the Supreme Court of the United States, that if the Supreme Court of the United States would get over its denial of our history of slavery, war, and Reconstruction, it might understand our reconstructed Constitution as something with a guarantee of human freedom, with a new guarantee of citizenship, with an assurance that citizenship carries privileges and immunities, with newly encompassing protections for everyone, citizen or not, to life and liberty. I'm not going to talk here about property. Much belated guarantee of equal protection of the laws. This Constitution should be understood as a Constitution that mandates resistance to supremacist ways. Should it do so, it would be like the South African Supreme Court, able to interpret the Constitution from a position of empathy with the experience of subordination. I speak of this kind of constitutionalism, some call it reactive, some call it post-colonial, with new inspiration as of just about a year ago, a little less than a year ago. The reason I'm newly inspired is not so much that things are different, but that I'm newly aware of things, I have to tell you. But the new inspiration for me is the unanimous decision of the highest court of India in the case in which it invalidated what the Honorable Justice Dr. D.Y. Chandrachud described as a colonial law that made it criminal, even for consenting adults of the same gender, to find fulfillment in love. The justice said this case involves much more than merely decriminalizing certain conduct which has been proscribed by colonial law. The case is about an inspiration to realize constitutional rights. It is about a right which every human being has to live with dignity. It is about enabling these citizens to realize the worth of equal citizenship. Above all, our decision will speak to the transformative power of the Constitution, for it is in the transformation of society that the Constitution seeks to assure the values of a just, humane, and compassionate existence for all of her citizens. To quote the justice again, the goal was to transform a medieval hierarchical society into a modern egalitarian democracy. What has this got to do with the child welfare system? I think you can guess. The autonomy and integrity of minority families in the United States child welfare systems depend upon deeply contested principles that have explicitly to do with liberty and are grounded in conceptions of human dignity and human right. Unlike the constitutions of South Africa and India and many other nations that see themselves as post-colonial, indeed, unlike the overwhelming majority of nation states on this planet, we have no constitutional statement of fundamental human rights. Our Bill of Rights is there, but it's a statement of protections against the federal government only. How and whether it protects against state power or against citizen suppression is highly contested. We have the Bill of Rights combined with a doctrine of incorporation, a doctrine that says that some, but not all, of the rights conferred in the Bill of Rights were or should be incorporated into the 14th Amendment and be binding on both state and national governments. And we have the language of the Reconstruction Amendments themselves, the 13th, 14th, and 15th. And we have the guarantee of a Republican form of government, but I put that aside for purposes of this talk. Reliance on a partially incorporated Bill of Rights has limitations because the language of the Bill of Rights fails to capture many rights that seem fundamental to most of us and to most of the world. There is no explicit right of political representation, or education, or public accommodation, or bodily integrity, or family, or personal integrity. There is no explicit right of equal protection. That leaves us with the language of the Reconstruction Amendments, which can seem promising. The 13th Amendment promises freedom in that it forbids subordination of the human will. The 14th confers citizenship with all its privileges and immunities. It guarantees to all the equal protection of the law, and it protects against denials of life, liberty, and yes, property without due process of law. The 15th suggests, but does not assure, a right of representation. In part, because of the Supreme Court's early and outrageously narrow interpretation of the Privileges and Immunities Clause. The so-called Due Process Clause, which prohibits deprivations of life, liberty, and property without due process of law, has been commandeered as the vessel for carrying fundamental human rights. It is a poor vessel, but it has been made to serve. We call the vessel substantive due process, and it was built for the most part in the area of family and child welfare law. It carries the right of marriage or family recognition, the right to procreate or choose not to procreate, and the right to keep and socialize one's children. We are in the midst of a constitutional crisis over this notion of substantive due process. For the judiciary is being flooded with judges who take a dim or narrow view of it. The contest is not binary. There are many ways of addressing the incorporation of human rights into constitutional language, but it's roughly fair to say that there are two camps. There are those who would interpret the law in terms of respect for human dignity and in light of both histories that should never be repeated and histories of which we are proud and traditions that should be continued. And there are those who would interpret the law in terms of the status quo. Those who champion interpretation in terms of the status quo cling to the principle announced in the 1997 Glucksberg case that fundamental rights are only those rights narrowly defined that have been recognized as part of the nation's history and tradition. The history and tradition camp is gaining ground. Looking only at the top of the federal judiciary, we see Justice Roberts, who holds up Dred Scott v. Sanford as the origin of substantive due process, associating it with the Lochner era, invalidation of the Louisiana Purchase and protection of the right to claim fellow human beings as property. Against this discrediting backdrop, he insists that adherence to, but not lessons from, history and tradition should be the lodestar for recognition of human rights. Justice Thomas argues that constitutional liberty is nothing more than freedom from physical restraint. And he has been a defender of Glucksberg's history and tradition test. Justice Alito emphasizes the importance of reliance on history and tradition and bemoans the fact that the Obergefell case may have overruled the Glucksberg test. Justice Gorsuch's views are less clear. Off the bench, he has expressed support for incorporating respect for human dignity into our constitutional understanding. And he has, to be fair, questioned reliance on, or exclusive reliance on, history and tradition. But he was quick to pen an alarmingly stingy interpretation of Obergefell in one of his first opinions on the Supreme Court. And his comments about substantive due process in opinions on the circuit level have been notably guarded. Justice Kavanaugh said in his confirmation hearings that all roads lead to the Glucksberg test as the test the Supreme Court has settled on as proper for determining the scope of individual liberty. And he claimed that even a first-year law student could see that Glucksberg is inconsistent with Roe v. Wade and with Casey, which upheld Roe v. Wade. These men, and they all are men, stand as a majority that could easily limit constitutional liberty to the kinds of liberty that can be protected by allegiance to history and tradition, narrowly defined. This limitation would protect sexist, heteronormative, and white supremacist practices against constitutional attack. It would make it harder for the Family Defense Bar to bring to light the perspectives of parents who are judged harshly merely because they look different or think, sound, and behave differently. It would make it harder for the Family Defense Bar to even sustain itself. We've talked about the right to counsel. More broadly, it would normalize, not only in law, but also in policy and practice, the paternalism, dare I say the patriarchy, that leads well-meaning advocates for children to distrust and disrupt rather than support viable families. That's it.
Wow, lot to talk about. Thank you so much. We do want to invite people to ask questions. If you'd like to use a microphone, you can. If you want to just raise your hand, that works too. But let's, I see we have someone who's ready to go. Would you?
Hello, my name is Maya, and thank you for the panel. Thank you for NYU. I'm going to date myself, but I have no problem with that. I graduated from the School of Social Work in '89 from NYU, and I've been in and out of the social work field, primarily in child welfare and also in the legal system for the past 30 years. So I'm a little uncomfortable with the fact that I could have been over, this could have been the same conversation when I graduated in '89. You know, that's going on here. So I totally understand that we need to have these conversations over and over and over and over and over and over and over again. So I'm happy for that, but it's just a little discerning to me. I really haven't been in academia as much. I pretty much haven't really been on the academic setting since like 2003. But so it's a little concerning to me that we're here where we are right now. So that's like the first thing I just wanted to point out. And then the second thing is that I think is it Yvette or is it Yvonne who's the person that was the email person on coordinating this? So I said to her when I emailed my response, I said, hey, do we have any C continuing ed for either social workers or lawyers? And the question the answer was no. So for me, that sort of validates the fact that this is not an issue. I mean, for me, this is obviously very informative. A lot of it is more or less validating that we're having this, and it was very, this is an educational setting, and the fact that we couldn't get any credits for this, not even one credit for coming to this symposium, says to me that obviously it's not a subject that's, considered important. And so that's another issue that I have with this, because I mean, as NYU is doing this, we should be able to get some credit, because we all know, at least some of us that are in the field and going to be in the field, we need to get continuing ed credits. And the fact that there's 0 here says to me that it's not really that important. So that's another piece that I wanted to point out.
So I would like to actually address that one, because it's a little more on me. And the point is well taken, and next time we'll try to do that. But I have to say, we do set up CLE and continuing ed for social workers when we feel we need to do that to draw a crowd, and we knew this panel, honestly, that was my thinking, we didn't need that to get people here. So
All right, well, on the other flip side, it's
it
like,
doesn't mean
it's
it was
an
the right
important
decision, but
issue,
that was
and we
the
need to-
thinking.
we need to
But
know, yeah.
please
I
give your
understand.
question for the panel.
All right, and then the last thing, I actually work for the Children's Law Center in the Bronx office. I was in the Brooklyn office before. I've worked for Legal Aid Society years ago, juvenile rights. And, you know, in terms of like custody, visitation cases versus neglect cases, I mean, you don't have to go further, but just to look at the disparity in those two populations right there in terms of the longevity of the court and, you know, all the biases you were talking about. You know, these cases don't move anywhere. It's sort of guilt. If you're in neglect, it's guilty until you're proven innocent. You know, you get these quick evaluations where, you know, in neglect cases that form people's lives, you know, and all of that. And then when it comes to a custody case, you know, the cases are drawn out because, you know, you're waiting for a forensic and all that other stuff. So, I mean, there's a whole lot of issues here, and I appreciate, again, that this conversation is still going on. And that's it. Thank you.
Thank you. Would you like to react to that?
Well, I'll say something. I'm even older than you, and I've been working in this even longer. And you know, I began working on issues involving the criminalization of pregnancy. I see Lynn Paltrow just walked in just as I said that. The punishment of black families, the biological explanations for social inequality. Since I began teaching in 1988. So I've seen a lot that has remained the same, but I've also seen a huge and exciting difference in the movements that are addressing it. I criticize the term racial disproportionality because I think it's too narrow, but when I started working on Shattered Bonds, that term didn't exist. That the people weren't even paying attention to the racial disparities. And then that became something that at least there was attention being paid to, but the idea that there was a way to connect movements. I just, you know, spoke before I came here with Aaron and Lisa. I don't know if they mind that I'm mentioning this, you know, an idea that they have for an organization that will connect movements. So we've gone from not even paying attention, you know, in terms of policymakers and other movements that have not paid attention to this issue, to it being incorporated more and more, and there's a lot more work that has to be done, into movements for social justice that see this not just as an issue of disparities, but as an issue of justice, and so much so that when I say this is an abolitionist movement, I'm not the only one saying that. There's you know, people working on it. Parent organizing I know that there were not the organizations of parents when I was, you know, in 2000 that exist now. So there wasn't, I don't want to say these struggles and movements didn't exist at all, but they weren't as organized and as influential as they are now. Reproductive justice, that wasn't a term yet in 1988. Again, long history of women of color working for reproductive justice, but there wasn't a term for it. There wasn't the amount of organizing going on. The connections weren't as vivid as they are now. And so I think we have to give credit to all the work that people have done for justice in this field that hasn't been acknowledged. And you know, who knows where we would have been if we didn't have this organizing. And there's a lot more potential now for it to actually make a radical change that I certainly did not see in 1988. So I understand the frustration of hearing the same voices and the same arguments about racism in the child welfare system. But I also think that we have to give credit and acknowledge and be inspired by all of the work, especially of parents who have been involved in the system against all odds, because, yeah. I don't think there's any other system where if you're involved in it and you work for change, it can actually hurt you. Like that could be a reason to take away your rights. And parents who advocate for change are brave like nothing you've ever seen, because they are struggling to be reunited with their children while they're being told, if you do this, this may be the reason you never see your children again. So I just want to lift that up as we continue to be frustrated by the fact that there hasn't been enough change.
Could I just say one thing, though? I appreciate the fact that there's this whole trauma focus piece that's going on right now, and I think that's like a paradigm shift that's really gonna, lend some force to this. So I appreciate it.
Hi, thank you for being here. You are very right when you say that parents who advocate for change are targeted. I consider myself a survivor. My son was unfairly taken from me. From the beginning, I realized that something was completely wrong with the system. I acted, I reacted, raised my voice, and yes, ACS and the foster care agency tried to malign me, to take me down. The louder I raise my voice, the more they campaign to terminate my parental rights. And I completely realized that this was just an organized campaign to try to not only tear me down. I was never in contact with the system before that. That was the first time I got into contact with ACS. And like everybody else, you think, okay, this is simple. You come to the house, you show them everything was fine, and the opposite happened. To the point, I'm sorry, what is your name? Yes. The point that you were making before, they come into your house and it feels like they're finding stuff to take your children away from you. Not only that, while your children are in care, they're finding reasons to keep your children more and more and more in care. And people don't understand why these children stay in foster care for 2, 3, 4, 5, 6 years. It's because they're building a case against parents. For example, they try to say that I had a mental health illness that my doctor had argued against. But they continued and continued to build that case. So after 5 years, the report came back that there's completely nothing wrong. Then why was my son in care for 5 years? I still don't understand. There is something completely wrong with the system. I quoted you, Dorothy Roberts, so many times, and I think I pissed them off. Thank you so much. During the TPR, which is the termination of parental rights, I quoted you while I was on the stand, and the judge looked at me and said, "Who you're talking about?" I said, "Dorothy Roberts, she's a scholar." And they hated me. They hated the fact that I was an educated and smart Black woman. That's what they hated the most. They hated that I answered to their email. They hated that I challenged their policies. I challenged their racism. I was outspoken even when my son was in care. I raised my voice and they hated me and they built a case against me. And right now I'm going through a reconstruction in my life because my son is home, but I have to deal with a child who cannot read on grade level because for the last 5 years, no one was investing in his education. he was put in foster homes of people who didn't give a crap about him. So now I have to deal the fact that my son is 7 and he's not reading on grade level. This is what I have to deal with. And I blame the system for that, and I understand it is programmed so that our children can't read and write. That's just part of the whole cycle. And I thank all of you for doing this work. Thank you for giving me a voice.
That's hard to follow. But I think what I'd like to do is invite a few more people to make questions and comments and then get reactions so we can get more voices in here as well.
Hard to follow, pretty amazing, but related. For parents who are, in the system now and who are dealing with these cases, often working with them, you have to draw a balance as someone who's working with them as a professional between, wanting to remain in your professional capacity and also not advise them to do anything that is going to hurt them, and knowing that advocating for themselves and organizing can have a negative impact on their case and their ability to reunify with their family, and knowing that this is a system of social control that really is keeping them busy and keeping them from collectively organizing. My very difficult question is, what do you tell those parents? Because their voices need to be heard for them to see, for them to be seen as people who are not fundamentally unable, and they aren't, even if they have mental health issues and challenges. And what do you say to them when you know that it could hurt them, but you also know that their voices are the most important voices to hear?
I think you tell them the truth. You tell them that having a voice can hurt you, and you tell them how that could happen. But it's up to them. That's why I'm talking about dignity and autonomy. It's up to these people to make that choice. And your job is to make it a well-informed choice. And you know all the risks, so you can do that. But it's a wonderful question. Thank you for it.
But it's also our jobs to not leave it to the parents to do it, right? It's our jobs to organize outside of, it's our jobs to make a social movement out of this. It's our jobs to take it to the streets so that parents aren't stuck with such a sort of diabolical choice, right? To express, and to humanize yourself and to demand that someone see your dignity, which jeopardizes your ability to parent your own child. So I don't think that it's fair for us to leave that to parents to make that choice. And so that's why, everyone who's not, doesn't have an open case, right? It's why academics and scholars and people, just people who are concerned about coercing, making this country live up to the things that it proclaims to hold dear, the things that are supposed to be, expressed and protected in our Constitution, right? It's up to us to not leave it to parents to make such a hard choice.
Yeah, you can. Go ahead.
I just wanted to kind of answer your question and piggyback on what you said, because the difficulty that I find as a parent affected is that I work with a lot of professionals, and I'm an equal and I'm a professional until I challenge them on some of the things that they're not doing correctly. Unfortunately, there's a lot of white professionals in this field, and we're do-gooders as white people, right? We want to save the poor black child that we know historically has been mistreated and is in the situation they're in today because of historic trauma and everything that has happened in this country. But then at the same time, when they say they're doing this, then you become the bad guy because you then speak up now against them too. So I find it hard to have allies and maintain allies in a way that because I'm often told to redirect what I'm saying or to say it differently. And I want to say it the way that I say it because I'm black and I'm proud and I have a right. I've been quieted for too long and I don't want to be quiet anymore. I want to tell the truth to whoever is misleading my community or misleading me or not stepping up in a way that they should be because they want to maintain their friendships. So everyone's afraid of the system. It's not just parents, it's attorneys, it's social workers, it's academia. Everyone's being careful, and I'm tired of it. If you really want to help parents, tell the truth. If you really want to help parents who can't read, and buy them an audio subscription, and let them read Dorothy Roberts' book.
Angela, why don't you go in then next? Okay.
Hi, thanks to all of the panelists and everyone who came out. It's just a wonderful learning experience. And I heard the word abolition a couple of times, and I was just wondering if there's more that any of you could share about what that concept means as applied to the child welfare system in a practical, as a practical matter. Thank you.
Well, I think I used it a couple times, so I'll speak up. I think the idea of abolishing an unjust system has been applied probably in the U.S. mostly to the prison system. And there's a literature on it. You know, Angela Davis has been very outspoken and has written books about it. And there are organizations that are prison abolitionist organizations. My understanding of what that means, and I think people have different kinds of ideas of what abolition means, is that it's in contrast to reform. It's in contrast to thinking that a system is basically a good one, but just has some problems. You know, that it was designed for a good social purpose, but it sometimes erroneously harms people. Instead of thinking that the system itself was designed to be unjust, to control and police and punish and marginalized whole groups of people, and therefore it's not enough to reform it. Reforming it sometimes just makes it work better. You know, we're better at harming people. What you have to do is abolish it in the sense that the entire philosophy of it, the entire way it's been set up, the entire structure needs to end, and something different, something radically different needs to take its place. Now, that's not as if it's going to, you know, we're going to tear it down today and then put in a new regime tomorrow, because realistically, we can't just are that, you know, we don't have the power, those of us who think it's an unjust system, to just tear it down. And we also are still working on even imagining, you know, how we would deal with social harms, for example, in a way that doesn't involve locking people up in cells. So neither aspect of it can happen right away. They both have to happen simultaneously. But to me, it makes a difference to how you even think about what our work is. You know, you think about what is it we need to do to abolish this system, and how important it is to be envisioning something radically different. So, you know, what's wrong with the system fundamentally? And so now how could we envision a society that deals with people's needs and deals with the way people harm each other in a different way? And I think that way of thinking should be applied to the child welfare system also. Again, if we think that it is not a system that's fundamentally designed to help people, you know, that it's fundamentally designed, you know, as you were describing it, to tear families apart, to pretend as if the reason why children are disadvantaged in this country is because of their parents, not because of structural inequalities. That the way it's designed to, in so many ways, prevent social change, in the way it keeps individuals from advocating for change, but also in the way it convinces a majority of people that there's no need for change. All you have to do is take the children away from bad parents, and we'll have less crime in America, we'll have less poverty in America. No, that's not true. That's not the reason. And in fact, as you pointed out, it leads to miseducation. It leads to locking up children. Not because the children were predisposed to it before they got in, but because the system itself calls police on them when they run away. The system itself lets them age out without any resources. The system itself traumatizes them, so they may turn to drugs to, self-medicate because of the trauma they've been through. So how do we then, so if we understand it as a fundamentally harmful system, it's not just about tweaking the mechanisms of it to make them work better. It's about eliminating the entire system. But just like with prison, it's not going to happen right away. There's so much money invested in it, and so much ideology invested in it, and so many people rely on it in order to meet their needs because that's the way it was set up. I did a little study in Woodlawn where I was trying to point out by interviewing Black mothers there that everybody was involved in some way in the system. They call it the system because that's what everybody knew what it was. It was the system. And I thought that they would, after they told me how it disrupted their families, all the harms it caused, I thought that my last question was, well, is there too much child welfare agency involvement in Woodlawn? It was Woodlawn in Chicago. Too little or just the right amount? And I thought they'd say, too much, get it out of here. No, the majority said there's not enough because it's the only way that we get benefits to take care of our relatives through kinship care. It's the only way that we get, cribs or whatever little pittance that the government is getting. Because TANF had been, had deadlines to it, and it doesn't even give you as much money. So right now, if you just, we couldn't do it, although I have to say, I'm convinced that families would be better off without it at all. But I'm just expressing what these women said to me was, we are relying on it, which is, like you said, it's pathological. It's pathological that people are forced to rely on a system that they see as harming them. That's the kind of system we need to abolish altogether. But again, thinking of our work as abolitionist work, it will change, I think, the kinds of policy changes we want to see. It will change the kind of organizing we want to do, and it will also mean that we have to think about, okay, what do we put in its place in order to support families? And so that's how, I don't see the person who asked the question anymore, but that's how oh, okay, there you are. That's right, I forgot you had asked it. That's an overview. And then what does it mean practically? I think we have to work on it. I mean, it's a brand new idea, relatively brand new idea. Work on what would that actually mean in terms of concrete advocacy and policy change and organizing.
I just want to add a little piece, it's 2 seconds. So like the distinction between reform-minded and abolitionist-minded, I'm reminded of a scholar, and I won't say her name, I'm just going to call, it's like saying Voldemort, but she says there's racial disproportionality in the child welfare system. Well, then the answer is to get more white kids in there. That's the problem, right? So that's the difference, like tweaking it, right? So for her, tweaking it so that it works better means that white kids are being excluded now, so we need to include white kids in the system. And so abolitionist-minded thought is like, there's something wrong with the system. It's being disproportionate, it's being terribly destructive to black families, but it would be terribly destructive to all families, white families included. So we need to get rid of the whole thing and imagine, dream up something else.
I'm sorry. Yeah, just back to the parent organizing question. So I understand organizing is a pivotal part of any sort of policy change, but it's also difficult to organize when you're in crisis mode. And if your parents, your children are being taken away, you're not moved to think about societal or structural change. But once that may be resolved, you're probably too traumatized to even engage with that system again, and engage with any of those attorneys. So my question is, how do we put the onus back on the attorneys to create structures for long-term parent engagement and organizing after the moment of crisis is resolved?
We should probably ask the parents, organizers, about I mean, that seriously is one way to think about it, is that we should be supporting parent organizers. And that's not to say that we, of those who aren't parents who have been involved in the system or are currently involved, shouldn't be doing anything. But I think we should be thinking about parents who are organizing as leaders of the, not to say putting the burden on parents to do all the work of organizing, but also not thinking of them as people who are in any way less capable of organizing. So to me, what should we do? I would ask, what can we do? What would help? What would help? And share the different kinds of knowledges that we have of how to transform the way child welfare is treated in this country at present.
Yeah, I think it's also about listening and respect. And I take heart in the fact that now we have representation groups that hire parents who've been in the system and think of them as professionals. Now, I hear you when you say that they don't always hear you and they don't always regard you as professionals, but that's the right path. The right path is to encourage people who have been through this to take a professional role in fighting it.
And I actually had in mind, like, people who have had no direct contact with the system feeling as if it's a moral obligation to be disgusted by the system and to be parts of movements or to organize movements themselves to challenge the system. So, for example, when the Trump administration began separating families at the border, people who had never had their family, like had people who were surprised, oh my God, the government would do that, right? Facebook, Twitter, right? Like folks who had no direct contact with state power, as violent and illegitimate as that, felt themselves personally affected by it. Again, folks who were not poor, not people of color, went to marches. Families belong together, right? So that's the type of empathy that I think I would like to see develop. I would like to see an empathy develop. There are more parents than non-parents probably among adults. I want to see people as their identity as a mother, as a father, feel themselves compelled to get involved in any sort of movement that is developing because they know how terrible it would be to have their child taken away, and they want to stop other families from having their children taken away. So, I see this it's about recognizing inhumanity. It's like recognizing a state that would deny the dignity of individuals. It's about forcing our government to live up to the things that it proclaims to represent in its constitution. And then, so that we're not leaving the onus on people who are directly affected by the system to do something.
Hi, thanks so much for this panel. All day long, I was looking at this weather and wondering why I'd ever left Berkeley, California to come here. And now I know why I'm here, so that's great. I want to just go back to a point that Kiara just made, like that we need to build empathy by bringing in people, even people who are not directly affected. And I guess I would just like to challenge, I don't know that there's anyone who's not affected by the child welfare system. I mean, the whole point of a system, a punitive system of discipline, is not just to discipline those who are directly affected by it, but to indirectly discipline those who are outside of it. And I don't think you can be a parent, certainly a parent of color, regardless of class privilege in the world, and not feel the psychic toll of the child welfare system in your life. Like if I have a child who gets a bruise and we're going to the doctor the next day, I mean, we have a story because I worry. And I think there are lots of parents who worry, and now you hear about parents who advocate free-range kids, and suddenly they find themselves in a situation where they're being investigated. I mean, I think those are the kinds of connections and opportunities for allyship to really show that there are people who are directly and traumatically affected by this, and I thank you for telling your story. But this system exerts a toll on everyone who parents, and like you cannot parent outside of it, and that's the point, I think, of it. And Peggy, thank you for connecting all of the dots, like bringing us into this historical conversation and thinking about it across systems. We have not really thought about like what we've been doing in the United States and how these things exert a push and a pull. Like for the last 10 years, we have been almost unduly focused on a fight for same-sex marriage, which was an important fight for equality. But even as we expand marriage's hegemony, we do so at the expense of calling into question the lives of individuals who live outside of marriage, and to sort of and to pathologize that. And that feeds into this whole crisis as well. So I think we need to think more systematically, as this conversation has done, about all of the different pulls and levers that are working to create a system where we are constantly disciplining people all of the time.
Okay, I think we have time for maybe two more.
Thank you. I enjoyed this very much. Thank you all. I wanted to get practical about abolition, and I wanted to bring up the fact that we have hotlines that call for everyone to report everything about everybody, and that are built on a complete lack of understanding of what real abuse is, what real neglect is, and that it really authorize what you're talking about in terms of the demonization of poverty, the demonization of mothers, the demonization of people, and are built on, that encourage this coercive interaction. And we could abolish hotlines, we could abolish registers, we could abolish the practices that are causing the separation of families. And that's not hard to reimagine. That's actually something that we can do as lawyers and as advocates and as families. So I wanted to suggest that there are practical ways to abolish the system.
Yeah, I think when we start to think about abolition and the steps we could take toward total abolition, one way to think about it, what can I do today that would be a step toward abolition? That's a great example. And in fact, one way we know we could abolish it is we know that there were laws passed creating these systems, and that laws are being passed to expand the abuse, the mandated reporters, and after the Jerry Sandusky, am I saying the right name? The Penn State, they're including people at University of Pennsylvania Law School advocated in Harrisburg for these laws that now expand who has the duty to report child abuse and neglect. So we've seen laws that have expanded it. We can also then advocate for laws that curtail it. And one example, it's related to the child welfare system related to the abolishing prisons, is just advocating for an end to bail, for example, the bail system that locks up people just because they don't have enough money for bail. Or even more practically, donate lots of money to bail funds that are about releasing people from jail. So maybe we can't abolish prison tomorrow, but we can help to release people from prison today. I think of that as a step toward prison abolition. So yeah, let's think about concrete steps we can take to chip away, not to reform, but actually chip away at this system, to break it down, to dismantle it. I think that's a great way to think about how to move toward abolition.
Hi. In the last couple of years or so, I've heard of more Black families beginning to file lawsuits against the system. So is that where there's teeth at, is standing behind families actually suing the system, class action lawsuits and such?
I think that, I think we have to, it's a one tool. I don't think it's going to be the only tool or even the main one that's going to dismantle the system, but it does bring attention to racism in the system. I am not aware of a successful lawsuit. Maybe some others are. I've heard of class action lawsuits. There's one that was in the news recently by a father in Minnesota who is claiming violation of his rights by the state removal of his children. And even in Shattered Bonds, I wrote about a lawsuit that was filed in Chicago claiming racial discrimination as a, by a whole class. I think there was one in New York at one point, and maybe in the 1990s as well. I don't, because of the way in which race discrimination is treated by the courts. In other words, in one of the cases, you have to prove that, if you were not Black, your child would not have been taken away from you. And so then the state just says, well, here are all the reasons. Here's what's wrong with this parent, and therefore there's no evidence of racial discrimination. And instead of looking at it as a political issue and looking at the ways in which Black communities as a whole are being affected by this, not basing it on the individual guilt or innocence of a person. I compare that also to arguments about race discrimination in criminal justice, like McCluskey versus Kemp, the case against the death penalty. Lots of evidence that the death penalty is racially biased, and that they showed all this evidence that Black people, especially if they're accused of killing or convicted of killing a white person, are many times more likely to be sentenced to death. And what did the court say? The court said, well, but McCluskey's guilty, so, right? So there's no discrimination here. And
we live in the United States.
Exactly. I mean, that's one of my I think the most honest statements in an opinion. I think it was Brennan who said, or it was either Blackmun or Brennan who dissented and said, this is all about a fear of too much justice, because the majority opinion said, if we grant this, we are going to have to find racial discrimination in every aspect of the criminal justice system, and then we'll have to abolish it, right? So, but think about that. That brings to public attention that actually is the reality of what would have to happen if courts really dealt with racial discrimination in education, in child welfare, in the prison system. They would have to abolish the whole system because it's racist through and through. And even if you're not going to win under the current jurisprudence, although it might be a way to push it to change, although, as you pointed out, Peggy, under this current conservative, it's probably not going to work. But part of the movement is to make people understand this. Most people in America think the child welfare system is a system to help, to save children, I think. I think that's part of why this organizing is so difficult. And the more, whether it's through lawsuits, whether it's through legislation, whether it's through rallies, whatever, to get people to see what it really is about, I think the more likely we are to get the changes that we've been talking about.
Well, one thing to add, I'm sorry, is that it doesn't have to be a suit that's about racial discrimination. So class actions in New York, of course, that were suits about taking kids away from mothers because the mother's partner had abused the mother.
That was a successful,
have great impact. It's extraordinary impact, really. So you can kind of work around the issue and help people.
I'd like to give Kira the last word, but I just wanted to fit in, if you'll let me.
No, I don't want the last
I don't want to be the last word. But I do want to let people know, because the issue of state central registries came up, that Joyce McMillan, one of the parent organizers that you heard from tonight, is leading a charge on changing the state central registry in New York, and anyone who's interested in hearing about that, I'm sure Joyce would be happy to talk to you about that once we break to the reception.
I just wanted to add a little point about the function of suits, and I wanted to tie it back to Professor Melissa Murray's point. Obergefell didn't just happen one day. Like the court didn't just say one day, you know what, let me recognize the dignity and humanity of same-sex couples, right? Like it was a long process. It was a long process in which law played a role, but law played a role in catalyzing cultural change, which played a role in changing the law, which played a role in catalyzing cultural change, which played a role until we got to Obergefell just a couple of years ago. So I think that suits, even though we might not be successful today, right? If we challenge the child welfare system, it might be a losing argument today, but in 10, 15 years, we're fighting for our children's, we're fighting for our children, we're fighting for our children's children. So there is a role for litigation.
Great note to end on, although we really hope it's not the end. We do want to invite you to stay and continue the conversation, but first, please do help me thank these three wonderful individuals for getting us here.